When the Supreme Court dismisses a request in less than 48 hours, that is not normal. It rarely happens. And when, on the very same day, your own lawyers begin walking away from the case one by one, this stops being politics and becomes a serious legal emergency. In moments like this, the court sends a clear message, one that is cold, firm, and impossible to ignore. The Supreme Court did not hold a hearing on Trump's emergency request. It did not ask prosecutors to respond. It did not take time. It issued a short order stating that the request showed no real chance of success on appeal. In legal terms, that is not just a denial. It is a rejection of credibility itself. This decision mattered because delay was the backbone of Trump's legal strategy. Pushing trials back, buying time, waiting for circumstances to change. With a single order, that path was closed. Lower courts were effectively told to move forward. No more waiting. The pressure intensified immediately. Once it became clear there was no safety net left, the situation unraveled fast. Within hours, 3 attorneys filed motions to withdraw from the case. This is highly unusual, especially with trials approaching. Lawyers do not leave at this stage unless something has gone deeply wrong. Each attorney used different language, but the meaning was the same. One cited a complete breakdown in the attorney-client relationship. Another said they could no longer advocate positions being demanded of them. A third used language courts take very seriously, an unwaivable conflict of interest. In the legal world, that phrase carries weight. It can mean a lawyer has learned information that could expose them to personal legal risk or force them to advance claims they believe are false. When that line is crossed, there is no negotiation. Lawyers leave to protect their licenses and their futures. When multiple lawyers exit at once, courts do not see coincidence. Judges begin to question whether the problem lies with the defendant's behavior or strategy. At that point, sympathy fades. Requests for further delay are viewed with suspicion, not understanding. This pattern is not new. Strong legal teams have formed before, only to fracture the same way. Former attorneys have described a client unwilling to accept legal advice, insisting on tactics that courts consistently reject. Courts do not reward theatrics. They punish them. Once delay is no longer available, reality takes over. Real trial dates, real witnesses, real evidence. If a defense is unprepared and the client refuses guidance, the structure collapses. That pressure is what broke this legal team. There is also a far more dangerous possibility. If no new counsel steps in and courts refuse further delays, a defendant can be forced to represent himself. In federal court, that outcome is almost always disastrous. The rules are complex, prosecutors are experienced, and even skilled attorneys rarely defend themselves. Confidence cannot replace legal precision. Instead of stabilizing the situation, public attacks on departing lawyers only made things worse. Courts notice this behavior. So do potential replacement attorneys. Lawyers evaluate clients as much as cases. When a client publicly threatens former counsel, it sends a clear message: representation here comes with serious risk. This situation is not just about one person. It is a case study in what happens when courts, counsel, and delay all disappear at once. The legal system does not respond to emotion. It responds to preparation, discipline, and credibility. This is the kind of analysis you find on the Union Voice. We don't just repeat headlines. We break down how power, law, and politics collide. If you found this video informative, like it. Subscribe to the Union Voice. Because this story is far from over.